When most people hear the term custody, they typically think of physical custody, but legal custody is a really important aspect of custody as well. Hi, I'm Max Ruthenberg-Marshall, attorney and founder of Porchlight. Today, I'm going to be addressing the difference between legal and physical custody. So let's start with legal custody. Legal custody is the ability for a parent to be involved in a child's life, make major decisions for them, and access the child's important records like school and medical records. In almost all cases, the parents are going to share joint legal custody. The courts believe that it's better for both parents to be involved and be helping to make important decisions for the child's life. So if the parents have joint legal custody, what happens when they disagree on a decision for the child? Well, in Georgia, we've designated tie-breaking decision-making authority for 4 major categories. Those categories are education, extracurriculars, non-emergency medical, and religion. Obviously, emergency medical needs to be decided in the moment, so that is decided by the parent who the child is physically with at that time. But for these 4 categories, if the parents can't agree, then one party has the ability to make the final decision on the matter. That doesn't mean that that party unilaterally gets to make a decision on those types of issues. There's a requirement that the parents negotiate in good faith and try and reach an agreement first before the tie-breaking authority can be exercised. So which parent gets this final decision-making right? Well, in schedules where there's a primary physical custodian, typically the primary physical custodian has the tie-breaking authority in all the categories. Whereas in schedules where the parents are sharing joint custody or a 50-50 schedule, then typically each parent gets 2 categories of final decision making. So what is physical custody? That may seem obvious, it's where the child lives, but it also includes the schedule of time that the child is going to spend with each of the parents. So in a traditional custody schedule, that's an every other weekend basis. So one parent has primary custody while the other parent sees the child every other weekend. Sometimes there are also dinners or overnights in the alternating weeks or during every week, or the weekend may be extended. But the basis of the schedule is every other weekend. There's also 50-50 or joint custody. So this is where both parents equally share parenting time with the children. It is typically done on an alternating week schedule or with something called a 2-2-5-5, where one parent gets every Monday and Tuesday, the other parent gets every Wednesday and Thursday, and they alternate Friday through Sunday. These certainly aren't the only custody options. You can come up with any arrangement between the 2 of those and be as creative as you need to. It's one of the best benefits of reaching an agreement with your spouse rather than having a judge decide, is that you can really tailor something to meet your family's needs. The third option is sole physical custody. This is extremely rare and is generally only done if the parent would be a danger to the child, if the child were in that parent's care. Even in those circumstances, sometimes that parent is awarded limited supervised visitation. The courts generally take the approach that having some involvement from a parent is going to be the best option for a child, even if that parent is not great at parenting. So how is custody decided? The standard is the best interest of the child, and this is a broad standard that gives judges a lot of discretion, but that also means that it gives parents a lot of discretion to reach an agreement that they truly feel is best for their children. Georgia law outlines 17 factors that should be considered in deciding the best interests of the child. And these factors are so broad, I would actually say they're categories of factors. They basically encompass everything in the child's life. And then there is a broad catch-all in the law as well that says the judge can consider any relevant factor. So really anything that's going to show what is best for the child. The judge is going to look at the history of each parent's involvement with the child and each parent's relationship with the child and determine what is going to be the best schedule going forward. Another factor that comes into play is the 14-year-old election. So here in Georgia, a child 14 years or older can elect which parent they want to live with. That's which parent they primarily want to live with. They don't get to dictate the entire parenting schedule. And if the child is 14 or older, this decision carries a lot of weight in the courts. The judge can go against this election if the judge feels that it is not in the best interest of the child to live with that parent, but typically the child's election is going to be what the court ultimately rules. Younger children 11 to 14, also have a right to make their opinion on custody known to the court, but it doesn't carry nearly the same weight as a 14-year-old election. So it's something the judge will consider, but it just basically in the pile of all the other factors for the judge to consider in that broad best interests of the child standard. So whether you've reached an agreement or you've gone to trial in custody, there's going to be a parenting plan that spells out all the legal and physical custody provisions in your case. This document is required for every case. I often get asked by clients who get along really well if it's really necessary, and it is. It's just a requirement of Georgia law. But if you do get along really well and you're essentially kind of figuring things out as hoc and just agreeing on an as-needed basis as to what the time is going to be with the kids, you can still continue to do that. The law just requires you to have this default backup in place in case you find yourself in a position in the future where you can't agree. So for these couples who get along so well that they really don't need a written document to guide them going forward in co-parenting, we go ahead and write out the document anyway because it's required, but then you can just put it in a drawer, put it away, forget about it. You don't have to look at it. You can continue to do anything that you and your ex-spouse agree on as co-parents. It isn't enforceable in court unless it's part of that court order, but if you're getting along that well, you probably don't need to enforce things in court. If you need help figuring out the best custody arrangement for your family, Porchlight is here to help you navigate that decision. Give us a call.